So coming back to today's video, today we'll be covering the remaining part of module 13. So we'll start with the topic of process to compel appearance, which is from section 61 to section 90 of CrPC. We often come across two terms which we use in the trial courts. One is the summon and one is the warrant. It always leads to most of the times it leads to a confusion as what exactly is the difference between summon and warrant. Summon is it is for your attendance before the court in regards to the questions that the court can ask you in relation to the case that is currently proceeding before the court. And warrant is used in various cases for the to procure the arrest of a person. Section 61 of your CrPC deals with the form of summons. What should be the form of summon? So, the bare act, the bare language states that every summon which is issued by a court under this code, which is your CrPC, shall be in writing in duplicate, signed by the presiding officer of such court or by such officer as the High Court may from time to time by rule direct and shall bear the seal of the court. So, the summon should be in writing in duplicate and it should be signed by the presiding officer of the court. Presiding officer here means the judge of that concerned court. If the summon is from the SC/ST court, it should be signed by the judge of that particular SC/ST court. If it belongs to the custom court, it should be signed by the magistrate or the session judge who is presiding over that court. Or, officers, the officers may be, authorized by the High Court from time to time who are authorized to issue summon. Moreover, it shall also bear the seal of the concerned court through which it is being served. Section 62 talks about how are the summon served. It states that, just mere showing of the summon does not amount to the serving of it. Actually, it has to be, handed over physically to the concerned person. Only then it is presumed under CrPC that the summon has been served. It states that, section 62 states that it deals with the personal service. The word personal service in itself is sufficient to show that it should be personally served upon the person. The mere showing to a witness of a summon is not sufficient service. If you show the witness the summon, that will not be a service. The summon should be left with the witness or should be exhibited to him and a copy of it should be delivered. Only then it shall be considered to be served as per section 62. Now, the question arises that how do we serve summon on corporate bodies and societies? For that, the answer has been given under section 63 of CrPC, which states that service of summon on a corporate body or society may be effected by serving it on the secretary or the local manager or other principal officer of the corporation or by a letter sent by registered post. So in case of corporate bodies and societies, it shall be addressed to its secretary or the local manager or the principal officer of the corporation, and it can also be sent by means of registered post. Now, why registered post? How does registered post serve as a proof? Because when you'll be going to the courts and practicing, the court asks that how have you served the summon or the notice to the other party, as regards this particular cause of action for which you have approached the court. So when you send the post, you get a receipt. That receipt is sufficient to prove that the summon has been served. Now, what does the term corporation under section 63 means? Under section 63, corporation means an incorporated company or other body corporate and includes a society registered under the Societies Registration Act of 1860. Now, sometimes what happens is that summon is served, but the person to whom it has to be served, he cannot be found. So for that, the answer has been given under section 64. This section provides that where the personal service cannot be effected and the person summoned cannot be found despite all the efforts, summon can be served on adult male member of the family, but not on servant, as he is not a member of the family. Suppose the summon has to be served on a person named X. He cannot be found. So it can be served to any adult male member of his family. It can be his father, his elder brother, or anybody. Section 65, talks about procedure when service cannot be effected as before provided, as provided in the preceding sections that we have discussed. Now, where the personal service is not possible, Section 65 provides for substitute service by affixing duplicate copy of the summons to the conspicuous part of the house where he ordinarily resides. Now, his attendance cannot be procured. Similarly, any of the elder members cannot be found. So, a duplicate copy of it can be attached to the conspicuous part of the house, and that will serve as serve as a proof that the summon has been served. Now, how do you serve summons on the government? For that, the answer has been given under Section 66. It must be served personally on the government servant by head of the office, and it would not be enough that he got knowledge of it. So it has to be served personally. In cases of government servant, it has to be served personally. For the answer has been given under Section 66. Now the question, Section 67 talks about service of summons outside local limits. Suppose the summon has to be served in a place which does not fall within the local limits of the magistrate who is serving it. So Section 67 provides that if service of a summon issued by the court is beyond the jurisdictional limit of a court, it shall be sent to the magistrate within whose local jurisdiction the person is either resident or is otherwise present. Suppose it is to be served by a court which is in area X, the person is in area Y. So, it can be sent to the magistrate who is residing in area Y, wherein the person to whom the summon has to be served is residing or is living there presently. Now, we will be discussing as to what are the differences between the summon and a warrant. Now, summon is an order to appear before the court. A warrant, it is an order to the police or other person to arrest a person. This is a very basic difference. In summon, you can be summoned by a court to appear before the court to answer the questions that a court may put forward in regards to the case that is pending in the court. And warrant is an order to the police or to other person to arrest a person. Summon is issued at a very first instance. Now, warrant is issued in very exceptional cases where a person is deliberately avoiding the service of summons. If he is avoiding the service of summon, then obviously, the warrant may be issued. Summon is used in less serious cases, and warrant is used in more serious cases. In summon cases, the magistrate generally issues the summon, and in warrant case, the magistrate may issue the warrant or summon. Summon are generally issued in summon cases. This is another point of difference which you can point out. And warrant are generally issued in the trial of warrant cases which we will be dealing subsequently. So that will give you a clear picture of it. Now, what Section 70 talks about the form of warrant of arrest and duration. What should be the form of it? Section 70 states that every warrant of arrest shall be, firstly, it shall be in writing. It shall be signed by the presiding officer. It shall bear the seal of the court. It shall bear the name and designation of the executant of such warrant. Indicate the clear name and address of the accused. State the offense with which the accused is charged, and indicate the date of issue. And indicate the date of appearance. So, I'll quickly again repeat what are the essentials of a warrant. It should be in writing, signed by a presiding officer of the court. The name and designation of the person who is executing the warrant. It shall, indicate the clear name and address of the accused, state the offense with which the accused is charged, indicate the date of issue, and also indicate the date of appearance. Now, Section 71 talks about power to direct security to be taken. Section 71 empowers the court to issue a bailable warrant. The warrant for arrest may also include a direction that if the person arrested under the warrant executes a bond and gives security for his attendance in court, he shall be released. This warrant which is issued, wherein, bailable warrant, wherein he's asked, to fetch, that he states, that he will execute a bond and pay some security, and then he'll appear before the court. So a bailable warrant can be issued. Section 72 states warrants to whom directed. Section 72 empowers the magistrate to direct one or more police officers to execute the warrant of arrest, and if in case a police officer is not available and the execution of such warrant is necessary, the magistrate can order any person to execute such warrant. Section 73 talks about warrant to whom directed. Warrant may be directed to any person. A warrant may be addressed to any person within the local jurisdiction for the arrest of, to whom the in respect of which persons the warrant can be issued. Any escaped convict, any proclaimed offender, any person accused of a non-bailable offense who is avoiding arrest. So in cases of these three, the warrant can be issued. Escaped convict, proclaimed offender, and person accused of a non-bailable offense who is avoiding arrest. Now, the question arises that where can the warrant be executed? Section 77 says that an execution of the warrant is not restricted to the local limits of the magistrate who is issuing the warrant. A warrant issued by a magistrate in India may be executed at any place. It can be, if it is issued in Lucknow, it can be executed in Delhi, in Bombay, in Calcutta, in Bangalore, anywhere. This is what Section 70 says. Anywhere within the territorial limits of India, it can be executed. Section 78 talks about warrant forwarded for execution outside the jurisdiction. A warrant of case to be executed outside the local jurisdiction of the court may be directed by the court to be executed by the police officer, or send the warrant to any executive magistrate or DSP, District Superintendent of Police, or the DSP of Police within whose jurisdiction it is to be executed. So Section 78 says, if the jurisdiction is outside the limit of the court which is issuing it, so they can issue it to the police officer, or they can send it to the executive magistrate or the DSP, who will then execute it. Section 80 talks about procedure on arrest of person against whom the warrant has been issued. Now, if an accused is arrested outside the jurisdiction of the court issuing the warrant, he shall be produced before the court if it is within 30 kilometers from the place of arrest, and the accused, if an accused is arrested outside the jurisdiction of the court issuing the warrant, he shall be produced before the court if it is within the radius of 30 kilometers from the place of arrest. Suppose a warrant has been executed by place named X. Person is in the place named Y where the warrant has been executed, and that place is within 30 kilometers. So he shall be brought before the court X, by which the warrant was issued. Now, the question, if the court is situated more than 30 kilometers away, but is still nearer than the executive magistrate or the DSP of that area, then he shall be taken to the same court. Now, as per Section 80, if it is within 30 kilometers, then he shall be brought before the court by whom the warrant was issued. Now, even if it is not within the radius of 30 kilometers, but is nearer as compared to the executive magistrate or the DSP, then he shall be taken. But if the executive magistrate or the DSP is nearer than the court, then the accused shall be produced before them. So whoever is nearer, he shall be taken to either the court or the executive magistrate or the DSP of police. No. Section 81 talks about procedure by magistrate before whom such person arrested is brought. The executive magistrate, the district superintendent or commissioner of police shall take the following steps on production of accused before them. What are the steps which are required are given under Section 81. If a direction has been endorsed under Section 71 for granting bail to the accused, which was about bailable warrant, the accused shall be released on bail after fulfilling the requirements. Secondly, if the accused is not released under Section 71, the magistrate can grant him bail if the offence is bailable one. And if the offence is non-bailable, he shall be sent to the CGM or the session judge. Now, we'll be switching over to the next topic, which is the proclamation and attachment. Section 82 talks about proclamation for a person who is absconding. Absconding, in its ordinary and etymological sense means to hide oneself, as the word suggests, absconding. When in order to evade the process of law, a person is hiding from his place of residence, he is said to abscond. No, the proclamation cannot be issued. The proclamation for a person absconding cannot be issued without first issuing a warrant of arrest. And it must mention the time within which and the place at which the absconder should present himself. And any omission to mention the time and place would render the proclamation a nullity. So, if the proclamation has to be issued, first of all, a warrant has to be issued and it shall state the date and time. If the time and place, obviously the time and place along with date is not mentioned, then the proclamation, the warrant will become null and void. Now, before issuing a proclamation, the court has to satisfy itself by examining the serving officer that a warrant of arrest had already been issued and that the accused is absconding. It has to satisfy itself. If the proclamation for a person absconding has to be issued, the court has to satisfy itself, by the concerned serving officer that the warrant was executed, that the warrant of arrest has been issued, but the accused is deliberately absconding. Only then the proclamation can be issued. Section 83 talks about the attachment of the property of the person absconding. Now, what is the object of this section? Because most of the times the object is asked. The object of the section is not to punish, but to compel the appearance of the absconder. This is what the object is, to compel the appearance of the absconder. An order for attachment of property under section 83 may be made at any time after the issue of the proclamation. Now, the issue of proclamation has been made. This process comes after that. The proclamation must be valid one, satisfying all the three clauses with regard to its publication. And it is mandatory to issue a proclamation as mentioned under section 82 before attaching the property of the accused. So, the condition, sine qua non, a prerequisite for the attachment of the property of person absconding is section 82. That is, a proclamation has to be issued first of all. Only then the property can be attached as per section 83. Now, the section 84 talks about the claims and objections to attachment. Now, if somebody's property is being attached, he has a right to claim because there may be chances that he is not the accused or he has been falsely fabricated in the case. This has been given under section 84. The attached property of the accused cannot be sold within 6 months. Suppose it is, issued, attached on 1st January. So, for a period of 6 months, it cannot be sold. During this period, if any person other than the proclaimed person can claim the property, that the property is not liable for the attachment. This section empowers any person other than the proclaimed person to raise objection or make any claim. The claim and objections in regard to the attached property can be preferred only so long as the property continues to remain under attachment. If the claimant or the objector dies, his legal representative can continue the claim. The claim can be made in the court by which the attachment of order is issued. Now, if the attachment of order is issued by the ST court or any court for that matter, the customs court or any other civil court or any other court. So, in that case, this attachment, the claim that a person is making shall be made before the court, which is issuing which has issued the order for attachment. But the chief judicial magistrate can also decide the objection himself or transfer the case for appropriate decision to any magistrate subordinate to it. So, section 84, I'll again just point out, a property has been attached as per section 83. If there is any person who believes that he has a claim to that property, then he can make an objection in that particular court, which has issued the order for attachment. Any court, whichever court is issuing it, in that court it has to be made. Now, section 85 talks about release, sale and restoration of the attached property. If the proclaimed person appears within the time specified in the proclamation, his property shall be released. The main purpose is to procure his attendance. If he has appeared, then his property may be released. But if he does not do so within the time, then his property will be at the disposal of the state government, which means that the government can exercise absolute control over it. The attached property, unless it is a perishable one, shall remain with the government for 6 months, which we have discussed in section 84. Where the property is sold, its sale proceeds shall wait for 2 years, and if during this period the person satisfies the court as to his absence, the money may be restored to him. Otherwise, it will be forfeited in the favor of the government. So, this attachment of property, first of all, it is attached for a period of 6. If he appears before that, if he appears within time stipulated, that the property may be released, they will wait for 6 years. If it is a perishable one, if they start selling it, whatever sale proceeds are coming will go to the state government. But if the accused person whose property has been attached, he appears before the court and he states and he satisfies the court as regards his absence, then the proceeds will go to him. Now, we will be dealing with some of the remaining rules as regards the process of appearance. Section 88 talks about power to take bond for appearance. The court may require any person to execute a bond for appearance before it or appearance in any other court to which the case may be transferred for trial. The only condition precedent is that the court must be empowered to issue summons or warrant of arrest. Section 88. The court can, require any person to execute a bond for appearance before it. But the only condition which is sine qua non, a prerequisite, is that that particular court must be empowered to issue summon or warrant of arrest. Section 89 talks about arrest on breach of bond for appearance. It states that if the person, after executing the bond for appearance in the court, fails to appear, the magistrate may issue warrant directing that such person be arrested and produced before it. We will be dealing with process to compel the production of things, which has been given from section 91 to 105. The topic of this video will be process to compel production of things. Section 91 states summon to produce document or other thing. It states that the court can summon the production of anything which is tangible or movable if it is necessary or desirable for the purpose of any proceeding before it. Now, for what purpose can it be necessary? For investigation, for inquiry, for trial, and for any other proceeding under this code. The court has inherent jurisdiction to call upon a person for presenting a document in the court which is in his possession, and it also has the power to compel the production of a document along with the personal attendance of the person. But if the order is only in regard to the production of documents, the person summoned can get it produced by his agent. So, section 91 talks about the summon to produce document or other thing. We have also seen that in Evidence Act, the courts are given, they can compel any witness can be asked to appear before the court. So this section, it states, that if he is in possession of any document, then he has to produce it before the court and he himself has to come. But if only the document is required, then his presence is not mandatory. He can produce it through his agent. Now, search warrant. Section 93 states that when can a search warrant be issued? For this, the bare provision of section 93 states where any court has reason to believe that a person to whom summon or order under section 91 or a requisition under section 1 of section 92 has been made or might be addressed will not or would not produce the document or a thing that is required by such summon, where such document or thing is not known to the court, where the court considers that the purpose of any inquiry, trial or proceeding will be served by a general inspection or search. Then, provision 2 states, the court may specify in the warrant the particular place and part thereof to which the search or inspection shall be made. Subsection 3 is important because it says nothing contained in this section shall authorize any magistrate other than a district magistrate or chief judicial magistrate to grant a warrant to search for a document, parcel or other thing in the custody of postal or telegraph authority. So section 93 states that if someone has been served as regards anything and they believe that if it is not produced, it may hamper the trial or the proceeding in the court, then a search warrant can be issued under section 93. There's a word used, reason to believe. What does reason to believe means under section 93? It means sufficient cause to believe the magistrate or the court may be satisfied that there is necessity for search warrant to be issued. Otherwise, the very purpose of the proceeding will be defeated. The word may used in this section, it confers a discretion on the court to issue the search warrant. The word inspect, it means inspection of a place, house or locality, and does not mean inspection of a document. Inspection of a place where the documents are kept. The document is found, it shall be produced before the court as it is. Now, section 94 talks about search of place suspected to contain stolen property or forged documents. Now, who can issue a search warrant in this regards? The district magistrate or the subdivisional magistrate or a magistrate of the first class. The police officer authorized to search must be above the rank of a constable, and the magistrate has to make sure that he has sufficient reason to believe that the place is used for the deposit of such property. So search warrant in respect of the places which are known to have, which are suspected to have stolen property or any forged documents. The magistrate, the DM or the subdivisional magistrate who is authorizing any police officer who is above the rank of constable to search that place, the magistrate should be satisfied and he should have strong reason to believe that the place in respect of which the search warrant is issued is having such things like forged documents or stolen property as provided under section 94. Section 95 talks about power to declare certain publications forfeited and to issue search warrants for the same. The government can order for the forfeiture of any material printed in a newspaper or any document if the government had formed an opinion that concerning documents contain any matter which is punishable under section 124A, 153A or 295A of IPC. If the government in its order of forfeiture has clearly stated the grounds of formation of such opinion. If any book contains highly objectionable and proactive writings which promote religious disharmony or feeling of enmity. So in these cases, they can, declare certain publications forfeited and issue search warrant for the same. If they believe, that the documents, contain publication which form an offense under section 124A, 153A, 295A, or they contain certain things which may, tend to create, we can say, which will disturb public peace and order. Now we'll be switching over to the next topic, the next section, that is section 96. Application to High Court to set aside declaration of forfeiture. The application which is made under section 96 can only be made if an order of forfeiture has been made under section 95. Section 95, which talks about power to declare certain publications forfeited, wherein we were discussing that, if they contain documents which, constitute an offense punishable under 124A, 153A and 295A. So what can happen in these cases? Application can be made before the High Court under section 95, under section 96, and this application will be against the order of the state government. Can be made by any person who has interest in such publication within 2 months. This time period is important. Suppose the forfeiture has been done of 1 January. So within a period of only 2 months, he can make an application to the High Court. Now, section 100, persons in charge of close place to allow search. It is the duty of the occupant of a place to provide free ingress and reasonable facilities to an officer making a search under a warrant as well as for search without a warrant. If an occupant of a place or a house does not provide free ingress or reasonable facilities to an officer making a search, the police officer conducting the search can adopt the procedure laid down under section 47, subsection 2, whereby the person executing the warrant is empowered to enter the place to ensure proper search. So it is the duty of any person who is in any close place, and if the police comes with the search warrant or without search warrant, and it is necessary for them to conduct it in respect of the particular case, the person should allow, or they can use the procedure under section 47, subsection 2. The search should be made in the presence of at least 2 independent and respectable inhabitants of that particular locality. It is a condition which is required. Now, section 102 is the power of the police officers to seize certain properties. Seize, to means taking physical possession of a movable property. And any police officer may seize any property which is suspected to have been stolen or found under certain suspicious circumstances, which create a suspicion as regards the commission of an offence. And the police officer has to report the seizure to the magistrate who is having the jurisdiction as regards that particular case. And in case the things seized cannot be transported to the court, the police officer can place them under the safe custody of a person, and the person has to execute a bond for the safe custody of it. Section 105, talks about the reciprocal arrangement regarding the processes. Section 105 makes provision for reciprocal arrangement regarding service of summons, warrants, including a search warrant within the territory of India. Now, if in case the court which issued such a process is outside the jurisdiction of the place where it is meant to be served, the process issuing court may send a duplicate of the summon to the court which has jurisdiction over that area, and the presiding officer of such court shall get the summons or the warrant executed. So this is about the topics that we have discussed in this video. Process to compel appearance from section 61 to 90, and then obviously the to compel the process to compel production of things. We have is what we have discussed in this video. If there is any question as regards it, please drop us a mail, and then we will answer it accordingly.